Hello, and good morning, good day to everyone. Thank you for joining us for this Mental Health in the Workplace webinar. My name is David Johnson, and I'm a CIMA member and one of the volunteers in Area 2, South West England and South Wales. I'm also a CIMA Council member and a member in practice, and I'll be your host for this webinar. We're delighted that today the webinar will be presented by Lauren McLaughlin and Jennifer Soule, both partners and in employment law and solicitors of Curzon Green Solicitors. Lauren and Jennifer, as both partners, they're specialists in employment law within the employment law team at Curzon Green Solicitors. The firm have offices in the City of London and in Buckinghamshire. Both are experienced in acting for employees as well as employers in a range of contentious and non-contentious matters. They vary from general HR advice and drafting contracts and agreements to litigating complex, multifaceted claims in the tribunals, high courts, and the Employment Appeals Tribunal, including complaints relating to dismissal, pay disputes, and discrimination. Also, they both sit on working parties for the Employment Law Association to respond to consultations on up-and-coming changes in litigation. It's a firm that has won many awards. Before I actually hand over to the speakers, there are a few points I'd like to make. To minimize disruption, you'll all be automatically have been muted. If you'd like to ask any questions, please enter the details in the question box, as there will be a short Q&A session at the end of the webinar, and I know both Lauren and Jennifer will be monitoring this themselves to be able to come up with anything as it occurs. Following the session, you'll be sent a link to the recording of the webinar and a link for feedback. Thank you, and without further ado, may I hand over to both Lauren and Jennifer.
Thank you, David. Good afternoon and welcome to today's webinar on mental health in the workplace. My name is Jennifer Soule and I'm a partner at Curzon Green Solicitors and head up our employment team, which I'm proud to say has been ranked by the Legal 500 as a leading firm for 2023, specialising in employment law. Curzon Green has 3 offices in the City of London and in Buckinghamshire towns High Wycombe and Marlow. Today I'm joined by my excellent partner Lauren McLaughlin. Together, our team undertakes work for both employers and employees on a wide range of matters, from internal grievances and disciplinaries to contract and policy advice, right through to litigation in the courts and tribunals. We're all members of the Employment Lawyers Association, as part of which I'd say we do some pretty important educating and lobbying of the powers that be regarding employment law as volunteers in addition to our day jobs. This week, as I'm sure you know, is Mental Health Awareness Week. So we thought it would be an ideal time for us to remind you of the employment law rights and responsibilities surrounding mental health, and also to provide some guidance for you as businesses and individuals regarding what to do if you or someone you know is in need of support. We'll break our discussion into 4 parts. Lauren will start with the practical management of mental health and well-being in the workplace, signs to look out for, the impact of staff, policies employers should put in place, and how to access the help that is out there. Next, I will look at the legal side in terms of discrimination, disciplinaries, and dismissals. Third, we have our usual top tips, 8 today. And finally, some questions and answers. Please do send your questions in as we go through the webinar, and we will deal with as many as we can, practical and legal, at the end. I'll now pass over to Lauren for our first topic.
Thanks for the introduction, Jennifer, and good afternoon, everyone. So our first topic today, as we've just discussed, looks at how employers can properly and practically manage mental health in the workplace. So as is well advertised, which is great to see, this week, 15th to 21st of May, is Mental Health Awareness Week. Every year, the Mental Health Foundation raises awareness of mental health, focusing on a specific theme this year, which is anxiety. Anxiety can manifest in unique and individual ways, like any mental health condition. Many of us have suffered anxiety, and it's one of the most common mental health problems. However, some groups of people are more likely to be affected than others. you can see on your screen a percentage of those in each category who were more likely to report high anxiety levels in a recent survey. Anxiety levels in the UK increased during the pandemic and have not dropped to pre-pandemic levels. Further, the cost of living crisis has undoubtedly led to increased levels of financial strain, putting people's mental health at risk. So the Mental Health Organisation's research provides that, worryingly, some of the behaviours that are good for positive mental health, for example, getting enough sleep, maintaining your connections with your families and your friends, are the very behaviours that people may be reducing to cope with the increased cost of living. So taking on 2 jobs, working extra hours, cutting down on family time and rest. Factors that might trigger anxiety in individuals will be different, and people who experience anxiety may well develop their own coping strategies to manage. So employers really need to recognise different ways it can manifest and how to spot this. When someone might be at a heightened state of anxiety, what the implications of this are, and how to support that individual. Not managing this anxiety or stress can lead to further decline with serious and potentially fatal outcomes. Thankfully, there's now a much greater willingness to talk more openly about mental health in the workplace. And this is what we're here to discuss in a lot more depth today. Institutional workplace change is happening, and we're seeing more appreciation from trained management that workers suffering with mental health problems can still perform well. They just need the correct support, and this requires understanding and proper training. A great place to start in respect of resources for this year's theme is the Mental Health Organisation's website. So you can see a link on the slide. That's full of extremely helpful information and resources. Anxiety UK is also a great charity with a lot of evidence which employees can signpost to their management if they're struggling. The Mental Health Organisation survey has asked those who took part if they had been anxious in the past 2 weeks. What was the cause of that anxiety? The 11 most reported cases are on the chart. The most commonly reported cause was being able to pay household bills, but that was closely followed, as you can see, by work, so reported by 29% of respondents. So not only should employers and managers be supporting those who are suffering anxiety and mental health conditions, but also be aware that the workplace itself could well be causing or contributing to those health issues. The warning signs. Awareness of mental health is increasing, great, but people with mental health problems still feel discrimination at work, and they can face challenges getting the help that they need. Many people who experience distress try to keep their feelings hidden because they're afraid of the responses and perhaps even poor treatment. Fear of discrimination and harassment are among the top reasons people give for not telling management about their mental health problems. Jennifer will talk about the legal claims that can arise in this respect a little bit later. The decision to disclose mental health condition is not one people take lightly, especially if the workplace is not known to be tolerant or supportive. Management really needs to be able to spot the signs. Some typical warning signs include employees obviously reporting the feelings of stress. This could be in person, in emails, Teams chats. It doesn't always have to be formally. The employee may be emotional or irritable, tearful, crying at work. They might isolate themselves, avoid colleagues, or appear distracted. You might find that employees procrastinate more, or alternatively just entirely grind to a halt. Employees might alternatively speed up, become chaotic, intrude in others' conversations and work, and take on more work than they can manage. So behaviours such as these should be trained to be spotted. Being impaired by alcohol might be noticed. This could be a coping mechanism, and attendance could be impacted with lateness, more sickness, absence without leave. Assessing struggling staff where they're working remotely can be challenging, obviously, and consideration should be given to how you can do this. Focus on the tone of emails and online communication. Consider the participation in Zoom meetings and team meetings and the timing of responses. How does anxiety impact performance? You can see an example of the worryingly endless cycle of anxiety on the slide. It can cause vicious circles where the impact of anxiety can affect people in a way that exacerbates that cause of anxiety. In the survey we've mentioned by the Mental Health Organisation, those 27 people who identified work as a source of the anxiety, you can see in that diagram how this might cause the anxiety to escalate and the work performance to continue to fail to improve. Mental health issues can cause someone to lose concentration, making it difficult to multitask and carry out day-to-day activities. And an employee's stamina could also be affected, deadlines again being difficult to meet. So this in turn could have the impact of affecting business productivity. So it's therefore both in the employer and the employee's interest to identify these early warning signs, try to understand the cause of those mental health conditions, consider what support can be provided, monitor and check in with staff, and then promote the ongoing communication. Looking at the cause of anxiety, stress, and mental health conditions, this can include an employee's disclosure of really quite sensitive and personal medical information. This can be to other staff members or to management. This could be through a doctor's fit note, occupational health report, or informal correspondence, as I've said, email, Teams, message. As an employer, it's like there are many other circumstances where health information is disclosed generally too, a medical questionnaire on starting work, sickness absence forms, and so on. Management really must be trained in dealing with this special category of data. Health data is a special category under the Data Protection Act 2018, and employers can retain and process this very sensitive data, but only in quite limited circumstances. So firstly, if the individual gives their express consent, or secondly, if it's necessary to carry out legal rights and obligations. For the most part, it will likely be necessary to hold this information for employers to create a safe place of work. But employers need to make sure that those circumstances in which employees can expect confidentiality of that really personal information that they've shared, that will be respected. But they'll also need to know when that might need to be shared with others in the business. If employees are encouraged to seek assistance and make these types of disclosures, they need to understand how that personal information will be treated by their employer, and they need to be able to trust management. To this end, according to Jane Carroll Black, good management can lead to good health, well-being, and improved performance. Good health equals good business, and the line manager is a key agent of that change. So are your managers trained and able to provide that support which is needed? In a recent survey by Mental Health First Aid, it discovered that 3/4 of managers said yes, they recognise that it's part of their role to act on mental health, but 1/3 admitted to feeling out of their depth, and they cannot be criticised for this if they've not been properly trained. Developing managers' confidence to have effective mental health conversations with their team makes good business sense on many levels. Data from the Workforce Institute shows that for almost 70% of people, their manager has more impact on their mental health than their therapist or doctor, and it's equal to that of their partner. So a relatively modest investment in effective wellbeing strategies at work, organisations can make quite a radical change to their workforce, their culture and profits. That same report showed a 5-fold return on investment for employers. So for every £1 spent on staff wellbeing, give an average return of £5.30 in reduced absence, presenteeism and staff turnover. Managers themselves should model good self-care practice. That's really important, inspiring their teams to look after their own mental health and well-being and to come forward without fear. We also suggest that the organisation considers other ways to raise awareness among staff generally, day to day. And there are reams of good ideas out there which do not take out too much time or cost. So for instance, wellness activities. This could be something as simple as a drop-in session to discuss worries, group exercise, lunchtime walks. Can the business conduct a wellbeing survey? This is a really great way to get direct feedback from staff, can be set up quite easily using the likes of SurveyMonkey, and it has the advantage of being set up and processed with a degree of anonymity. Creation of wellbeing channels on Teams where staff can share stories, ask questions and post about helpful guidance and resources. Does your employer offer employee assistance program counselling, EAP? Can the business consider enhanced sick pay? Can it offer leave and breaks? These could be paid or unpaid. Promotion of the use of self-help apps like Calm and Headspace. And consider the circulation of wellbeing newsletters. Could be once a month, and it could cover any programs and initiatives, and it can really promote that culture within. Why should employers do this and treat mental health with the importance that we say it deserves? So in addition to a healthy, happy workforce, there are other business reasons. 84% of employers in the UK believe that staff who feel their mental health is supported are less likely to leave. Unhappy people leave, and a happy and retained workforce is obviously better for business. Failure to support the workforce impacts your talent pool and your recruitment. And reduced absence levels and with supportive return to work programs reduces cost. There's also a lowered risk of employment tribunal claims if matters are dealt with fairly and properly. And to this end, Jennifer will look at the employment law aspects in our next section. An employer may set out its approach to mental health in a mental wellbeing policy. Staff can have a central reference point from which they can understand the employer's position, and that can be they can be directed to the resources they need. It can be very helpful, and it can be relevant evidence to show an employer's approach on paper too. So it can address the employer's commitment, its openness, the training that it's undertaken, make everyone think about the adjustments that might be needed, encourage staff to seek help and who from, and signpost the other supports available. These policies are becoming more and more common, we're seeing, not least as a good source of information, but it sets the tone on the company's approach. Employers should, however, ensure that they can and do follow through on these commitments made on a policy. A tick box exercise is really not good enough. These types of policies can be included in an employee handbook and can be circulated and should be circulated to all staff. And finally, employers should consider the interplay of mental health in other workplace policies, so such as in their absence procedures, bullying and harassment, grievance, and so on. And to do this, a full review globally of the interplay of mental health is really required, rather just taking it, as I say, a tick box type approach. A full update to the handbook and day-to-day practices is necessary with mental health conditions at the forefront. Jennifer will be looking at the risks of not doing this properly and not taking the global approach next, and also looking through risk assessments and other things which can be undertaken in the employer's full review. I'll pass it over to Jennifer now.
Thank you, Lauren. So Lauren has touched on how to manage mental health in the workplace quite practically. I'm now going to recap why it's important to do so legally. For those of you who attended our last talk, I apologise for some of the repetition in this section today. However, we cannot escape an employer's duties in terms of general matters of health and safety and the well-being of its workforce. The starting point is that whilst an individual is at work, whether in their home, on site, on the road or in the office, they are under an employer's duty of care. At common law, employers must provide and maintain a safe place of work and a safe system of working. Under statute, the Health and Safety at Work Act states that an employer has a general duty to ensure, so far as reasonably practicable, the health, safety and welfare of all its employees. To achieve this, employers must conduct suitable risk assessments, considering the sort of work people are doing, whether they have the equipment to carry out their role safely, and how they can report any issues. These risk assessments should cover mental health issues as well as physical issues. They should be kept up to date and reviewed where there has been a significant change, such as new equipment, new systems, or an employee's new health disclosure. An employer needs to provide comprehensible and relevant information to employees about any risks that are identified by the assessment and what measures they'll implement as a result. Failures or breaches of employees' health and safety leave employers at risk of a claim in the courts. And mental ill health may amount to a disability. It's one of the 9 protected characteristics under discrimination legislation in English law, and it is a disability in the eyes of the law if it is a condition where the effect is substantial, so that means more than minor or trivial. An example is that it would take longer than usual to complete a daily task such as getting dressed. And long-term means that it has lasted or is likely to last 12 months or more. And you may need medical evidence here if the illness has not lasted 12 months yet. Cases involving mental impairment is often less obvious to ascertain whether the employee is actually disabled. And it's therefore prudent for an employer to obtain a medical report to make this assessment. In borderline cases, the newest ACAS guidance states that employers should proceed on the basis of an assumption that the employee is disabled. If an employee is disabled in the eyes of the law, then the employee is covered under the Equality Act. That means that a disabled employee has enhanced rights and protections. Disabled employees can bring claims against their employer for various types of discrimination: direct, indirect, failure to make reasonable adjustments, and also discrimination arising from disability. Unlike claims for unfair dismissal or redundancy, there is no minimum qualifying period for employees to be able to bring discrimination claims. And there's no upper limit on the compensation which they can be awarded, which usually includes an award for injury to feelings. Therefore, it's vital that employers ensure that they deal with employees who meet the definition of disability reasonably, fairly, and in line with the law, or else they could face a costly claim. Direct discrimination is set out in Section 13 of the Equality Act. It's when somebody is put at a disadvantage and treated less favourably because of their disability compared to somebody without that disability. In the slide, there's the example of Aidan. He has a job interview and is offered the role along with 3 other candidates. After he's been successful, he tells his new employer, that he's suffered from depression, and that employer withdraws the offer of the job, but doesn't explain why, even after Aidan asks for an explanation. Aidan's job is the only one that's withdrawn. If the reason for withdrawing the offer was because of his depression, then that would be direct discrimination against Aidan, and the employer would have no statutory defence to that claim. Indirect disability discrimination is much more subtle. It's where a provision, criterion, or practice which applies equally to everyone puts someone who suffers a disability at a particular disadvantage when compared with others. Employers can justify this in some circumstances. On the slide, we have an example of Hina, whose employer has put in place a new shift pattern which applies to all staff. They must all accept it. Hina has acute stress disorder for which she takes medication, and that makes her very sleepy in the evening, so she isn't actually able to work late shifts. The employer's policy of changing the shifts is likely to be indirect discrimination because it puts Hina and others in her position at a disadvantage. It will not be discrimination if her employer is able to justify the new shift pattern by showing that it is both for a good reason and appropriate and necessary. Employers are under a duty to make reasonable adjustments in the workplace to alleviate or remove any disadvantage suffered by a disabled worker when compared to a non-disabled worker. This could be physical changes in the workplace or equipment, or changes to how processes are run, or information is supplied. Reasonable adjustments often involve little or no cost or disruption, but a failure to make reasonable adjustments can result in a claim and liability. It's also bad PR. What is reasonable is a question for the courts, but cost is very rarely enough. The only defence is to have no actual knowledge or no actual constructive knowledge about the disability and the disadvantage. A sensible starting point for employers faced with someone who is off or persistently late, for example, Laura mentioned lateness earlier, is to review any fitness for work certificate, have a discussion with the employee to explore potential for disability, and or commission an occupational health assessment. This will usually contain advice on what changes can be made at work to help with the individual's recovery and their attendance and timekeeping, such as phased returns or alternative hours. Must remember, when running processes, advice should be sought from a medical expert on the employee's ability to take part, involve extended breaks if they need more time. The example on the slide is Daniel, who works as a cleaner in the hospital. He has anxiety, particularly about picket lines and strikes. And so very recently, he's been late for work several times. Usually, his employer would discipline for lateness, but because he's worked there for 2 years, his employer knows of his issues and his diagnosis and medication. The strikes have led to a disadvantage for Daniel, and so his employer is going to make reasonable adjustments to ignore his disability-related lateness and can also amend his start and end time to minimise his contact with strikers. There's also discrimination arising from a disability. This is when somebody is treated unfairly or put at a disadvantage, not because of the disability itself, but because of something that's a result of the disability. In the example on the slide, Agatha has depression. Very recently, she's had 3 periods of sickness absence because of this depression. Her employer is in the unfortunate situation of needing to make some redundancies, and when carrying out that exercise, Agatha's employer has considered past absences of employees as part of its decision-making matrix. This means that Agatha is scored lower than her colleagues. She has been treated unfairly, not directly because of her disability, but because of something related to her disability. This could be discrimination arising from Agatha's disability, which may be justified if it can be shown that the treatment is a proportionate means of achieving a legitimate aim. And that would be a question for the tribunal to consider, presumably when having a look at the remaining questions in the matrix. So for employees bringing a claim to the tribunal, they would value their claim in addition to losses as injury to feelings, which are damages which the tribunal can award to compensate an employee for stress and anxiety suffered as a result of the discriminatory treatment. The compensation is considered separately from any claim for financial loss, such as loss of earnings. Tribunals ultimately have discretion as to what amount of compensation to award, but as you'll see from the slide, the vento bands are considered when determining this amount. The lower band is 1,100 to 11,000 more or less. We've got a middle band for cases that are more serious than one-off or an event that has happened 1 or 2 times. But they're not significantly serious for an award in the upper band. They're 11,200 to 33,700, so that's quite a range. And finally, the upper band for very serious cases is 33,700 to 56,200. And then for most exceptional cases, you can blow that cap as well, and awards can be made exceeding 56,000, but those awards are seldom made. In addition to the discrimination claims brought under the Equality Act, employees with 2 years continuous employment have the right to bring an unfair dismissal claim. There are 5 potentially fair reasons to dismiss an employee: conduct, capability, redundancy, illegality, and some other substantial reason, which is a catch-all category designed to allow employers to terminate an employment contract when none of the other potentially fair reasons apply. Case law examples include a breakdown of trust and confidence between the employer and the employee, conflict of interest, the employer's need to change terms of employment, reputational risk, and even personality clashes leading to a toxic workplace. In the context of mental health at work, we're likely to be looking at a capability dismissal. An employee is too unwell to perform the role that they are paid by the employer to do. There are circumstances where a decision to dismiss could also involve misconduct if, for instance, the employee's mental health impairment or their medication leads them to behave in a way that's not acceptable to the business. Likewise, an important client of the employer insisting that the employee is dismissed, otherwise they'll take their business elsewhere. That could be an SOSR dismissal. The risk is that if the employee's depression or other mental illness is considered a disability, they have protection from unfair dismissal from the first day of their employment, because disability is considered the protected characteristic, as I mentioned before. As such, the managers in a business should proceed with caution when dismissing for reasons related to mental health, even when an employee has not worked for them for 2 years or more. Additionally, even though there may be a fair reason or reasons, the dismissal is only fair if management also act reasonably. There's no legal definition of reasonableness, but if you're taken to an employment tribunal, they would consider whether you genuinely believed the reason, genuinely believed it was fair, that you carried out proper investigations, that you followed the relevant procedures where appropriate, you told the employee why they were being considered for dismissal and listened to their views, you allowed the employee to be accompanied at dismissal hearings, remembering to make reasonable adjustments to those processes as previously advised, and that you gave the employee the chance to appeal. Reasonableness might also depend on whether the employee could be expected to understand the consequences of their behaviour. An employee who is successful in a claim for unfair dismissal would be awarded compensation by a tribunal made up of 2 parts. The basic award, which is worked out taking into account an employee's age, years of service and weekly pay, which could be as much as £19,290, and a compensatory element, which is up to a year's salary, or £105,707, whichever sum is lower. If the dismissal is related to an employee's disability, however, that cap is blown and the employee will be awarded the injury to feelings compensation in one of the Vento bands, in addition to the financial losses. Moving on to talk about alternatives dismissal, unfair or otherwise. We all know that failing to deal with stress in the workplace poses a risk to businesses and can result in higher sickness absence, reduced productivity, and poor performance. Poor performance from stress can include uncharacteristic errors, loss of motivation or commitment, memory lapses, increased time at work, lateness at work. None of this is good for the employee nor for the employer's business. Performance management will need to ensue. During such a process, employers must question why their employee may be underperforming and should be mindful that if formally dealing with performance management issues through a performance process, that due consideration is given to mental health being a factor or the underlying cause for the poor performance. If it is, employers should consider the cause and any additional support that might be needed. They should proceed on the basis that there is a need to make reasonable adjustments due to the ACAS recommendation that we assume that somebody is suffering from a disability if there's a mental ill health in play. Can their workload be reduced? Can duties be absorbed elsewhere? Can the employee do work in a different way? All of these are reasonable adjustments. The dismissal of an employee on the grounds of performance, where their performance is because of or related to mental ill health or stress, may result in the claim for unfair dismissal in addition to the complaints under discriminatory legislation that we've discussed. You can see an example on the slide where Rohit has been disciplined because of some anger outbursts that he's had and a drop in his performance. Because his employer didn't investigate properly, they didn't know that he was suffering from extreme anxiety. And while he's asked for support, they haven't listened. Had the employer had regular performance reviews and made reasonable adjustments, the disciplinary might not have been required. Any sanction is likely to be discriminatory here, and any dismissal resulting from the disciplinary action may be unfair. Similarly, mental health must be considered during any disciplinary process, not just in respect of underperformance. In the previous example, Rohit was having anger outbursts because of his mental health condition. A thorough and fair disciplinary investigation should be conducted to explore this and reasonable adjustments considered. Adjustments should be considered not just for the outcome, but for the process itself too. For instance, does the employee need longer to prepare their evidence? Do they need mental health support in the meeting? Are they fit and well enough to attend the meeting in person, or could you do it via another platform? Do they need extended breaks? Medical advice should ideally be obtained here. The employee could raise a grievance if they feel that they have been treated poorly because of their disability or mental health, and they could ultimately bring a costly claim against the employer under the Equality Act, as I have flagged. Employees often get signed off during internal processes to avoid disciplinary action, but it could be because they are genuinely not well enough to deal with matters at work. Their colleagues are left to pick up the slack, causing further stress and potentially illness in the workplace. So it's obvious that reasonable adjustments need to be made, not just in respect of that employee, but when considering all employees' mental health. If employers want to dismiss an employee, they need to have reached a fair decision and have acted reasonably. According to a CIPD survey, in 2020, 17.9 million working days were lost to stress, anxiety, or depression. Employers are suffering with a reduced workforce and the need to cover absences and workload. Employees are suffering because they're losing pay. But if someone is sick, they need to be able to rest, recover, and employers should consider how to contact them while they're off sick. They should follow sickness absence policies. Agreement needs to be reached on contact with the stressed employee. How often and what platform should they use? A balance must be struck between keeping in touch and not aggravating the employee's illness. Professional advice should be sought regarding the employee's eventual return to work. However, what if that return seems unlikely for the foreseeable or even well into the future? It's a frequently asked question. Could I be dismissed because I'm too stressed and have been signed off for an extended period? As you can see from the slide, the answer is yes, potentially. If you're suffering from a significant level of stress, you may well have been signed off work by your GP, and your employer is not obliged to keep your job available to you on an open-ended basis. They could ultimately dismiss you for long-term sickness absence, or if they consider you are no longer capable of carrying out your role, as long as they carry out a fair process when doing so. This means that the underlying reason for the absence should be investigated. If there are signs of stress-related illness, medical experts should be sought, either by your medical team, your GP, or anyone else that's involved, or by one that your employer appoints, such as occupational health. It may be that the stress is down to the way you have been treated by your manager or an overload of work, that needs to be resolved by your employer rather than leading to your dismissal. Reasonable adjustments to help you get back to work should be considered. If this does not prove possible, then your employer may ultimately be justified in considering a dismissal based on your illness. It's one of the fair reasons for dismissal, but it should be the last resort. So once a fair process has been followed, then a dismissal would be fair. If not, there is a potential claim for unfair dismissal, attracting the awards of 1 year's pay and uncapped injury to feelings, as I've mentioned. Long COVID is not a mental health condition. However, it can be considered a chronic medical condition that elicits many mental health symptoms. A sizable minority of people who catch COVID develop long-term, often debilitating ailments such as fatigue, breathlessness, mood swings, brain fog, and heart problems. This is called post-COVID syndrome or long COVID. And people can experience the effects of long COVID for weeks, months, even years. Symptoms can come and go over time, sometimes get better, sometimes worse. This means long COVID can affect someone's ability to work or cause them to take time off sick. Roughly 1 in 6 middle-aged people and 1 in 13 younger adults in the UK have these symptoms that persist for more than 3 months. There's no specific treatment available yet. And you'll remember that if these symptoms impair their ability to perform day-to-day activities for 12 months or more, such individuals will be considered to have a disability for the purposes of the Equality Act. There are thought to be multiple causes, ranging from an abnormal immune system response to damaged tissue and residual virus lurking in the body. Psychiatric studies are now showing that there may be a relationship between mental well-being and long COVID, because psychological distress can drive chronic inflammation and disrupt the immune system, potentially making people more vulnerable to long COVID. Statistics have shown that those who suffered from depression, stress, anxiety, loneliness, and worry before catching COVID were more likely to report symptoms lasting more than 1 month. An organisation's usual rules on sickness absence will apply when someone is off work because of long COVID. Employees should check internal policies to find out what these are. Like with any disability or potential disability, employers and managers should agree how and when to make contact with employees who are absent with long COVID, ensure their workload doesn't back up while they're too ill to attend work, and support their return to work, perhaps with reasonable adjustments. Employees should cooperate with employers in facilitating their return to work. Employers should make sure they've done everything they can before considering a capability procedure. If an employer dismisses an employee without first carrying out a fair disciplinary or capability procedure, the employee could bring a claim for unfair dismissal to an employment tribunal. The usual rules of sick pay apply, and any employer needing help or assistance should check out the ACAS website. They have a suite of policies, guides, templates, and toolkits. And also there's government guidance that's been written by the DWP, which I can send the link around for afterwards because I realise I've omitted it from the slide. Apologies. So now handing back to Lauren to give you our top tips for a healthy workforce.
Thanks, Jennifer. So that was a really interesting overview on the employment law elements that could be at play. So our top tips, we've got 8 of them today. So our first tip is to check that you or your employer is following the HSE, the 6 HSE Standards. So the Health and Safety Executive is Britain's national regulator for workplace health and safety, and this includes mental health. So the HSE Standards cover 6 areas of work design, and if not, that need to be properly managed. And if they are not, they can result in poor health, lower productivity, increased sickness, absence rates, and mental health conditions. So demands, looking at workload, the pattern that you work in, your work environment, control, what say does the employee have in their day-to-day work, support available to the employee, relationships, so promotion of that positive working relationship really has to be looked at. Role, does everyone understand their roles in day-to-day work? And change, how to effectively manage organisational change with health in mind. For instance, looking at redundancies and restructures. HSE have a really great free workbook for employers, which provides good advice and guidance. It includes a really helpful checklist to allow an employer to be sure that it's achieved what's required at each step. That can be printed off free of charge and kept as evidence of what the employer has done. There's also advice for employees. This looks at what the 6 standards should mean for them, as well as what action they should take if they feel they're becoming stressed at work and perhaps the employer has not done what it needs to do. Tip 2, use ACAS. So ACAS is a free conciliation service. It provides training and support in respect of conflicts and discrimination. ACAS produce a lot of up-to-date helpful guidance. for employers and employees. And ACAS's guidance on mental well-being and its framework for positive mental health at work are really good. They map the role of managers and the organisation as a whole, as well as how individuals can support themselves and what they can and should do, perhaps if they think things are going wrong. It's an excellent starting point and a source of general day-to-day guidance, and we highly recommend that you check that out. Tip 3, update your data protection and privacy policy, or check if your employer has done so. So as discussed earlier, health data is special category data. Make sure your data protection policy is detailed and it covers health disclosures, including places to report and record those reports of sickness, stress and anxiety and other mental health conditions, the contents of OH reports and fit notes. Who will they be shared with? Are they secure? Who can access these? How long will the employer retain this data? Employers must ensure that this complies with the law and train staff who will handle this very sensitive data. Step 4, lead during change. So the world of work is changing and many employers find there is a need to restructure or to make redundancies, and they might need to change staff working conditions or contracts. Any change process could be challenged for staff with poor mental health. If employers have planned a change process, mental health must be considered. You can balance some of the obvious stressful impact aspects by ensuring that decisions are communicated effectively, that people have as much time as possible to digest decisions, and that support is made available both within the workplace and by external support, such as EAP, we mentioned earlier, and support to find new employment. So outplacement support is readily offered by good employers nowadays to help employees move forward. For employees with poor mental health, change processes can be especially stressful. They may expect to be made redundant. They may need that extra support. They may actually become unwell because of the change, or conversely, may not put themselves forward for promotion when perhaps they are suitable. If you have staff who you know have a history of mental health problems, or you should reasonably be aware, you spotted some warning signs, for instance, it is really worth specifically adjusting for this when planning change. Step 5, appointing mental health first aiders and champions. Mental health first aid is a programme that teaches first aiders how to help a person experiencing varying degrees of mental health issues. The training teaches people how to offer initial support until appropriate professional help, which obviously should be sought, is received, or until the crisis resolves. Mental health first aiders can provide that first level support and early intervention, encourage the person to identify and access sources of professional help. They can help practicing listening and provide empathy, and have conversations with improved mental health literacy around language and avoiding stigma. A mental health champion could also be appointed as someone who will raise awareness more generally in the business, implement wider strategy, and actively be available to provide advice and signposting support, essentially a point of contact. However, it should be recognised that while staff can be encouraged to speak about to a mental health champion, they may find it easier to speak to someone who is not a manager. This is where designated colleagues who are first aiders can assist too. And having a designated first aider and mental health champion demonstrates a real sense of company support. Step 6, put in place a mental health plan. So in addition to those first aiders and employers, put everything into action through a proper plan. This can include developing your awareness and accessible documents that everyone can see, and routinely monitor health data, so look at your sickness absence data. Ensure return to work interviews are conducted consistently, and trust can be gained through regular one-to-one meetings with staff. monthly drop-ins, or even a weekly brew-up to get people talking. Number 7, addressing discrimination. So ensure discrimination on the grounds of mental health status is seen as to be unacceptable as discrimination in relation to other protected characteristics: race, religion, age, sexual orientation. Train staff on how mental health can be a disability under the law, as Jennifer helpfully explained. Appropriate workplace adjustments to be put in place, and make sure they're right from the recruitment process right through employment and at regular interviews. And encourage staff to report discrimination or harassment and to blow the whistle in any wrongdoing, and ensure that those complaints are dealt with fairly and robustly. Support national and local anti-stigma initiatives such as Time to Change and, of course, Mental Health Awareness Week. And finally, it's really important to lead from the top. And our final point before we move on to your questions: communication is key. So encourage those open conversations. Employers should promote effective people management through your line managers and supervisors, and all staff should have regular conversations about health. Remember that the best the best expert on a person's needs is themselves. So if there's one golden rule for supporting a colleague at work, it's never to assume and always ask. You can do this via confidential and sensitive discussions, but also remember that not everyone is willing to be open. Where an employee is guarded, taking steps we've discussed today should help open up sensitive communication and a supportive environment. You should also remember not to put yourself in the place of the medical expert, because we're mostly not trained in that. I'll now pass back to Jennifer for some closing remarks before looking at your questions.
Some great tips there, I would say, and hopefully we've given you some food for thought this afternoon from both an employer and employee perspective. A few final points before we move on to our question and answer section. The contents of today's presentation is up to date as far as possible, but you should always check the current legal position and, if in doubt, take timely professional advice on your situation. So we've had a few questions which we can turn to. How much time have we got left? Got a few minutes. Let's have a scroll up.
So we've got an interesting question. Is it appropriate to ask during a job interview about the history of sick days and levels of anxiety presented by an interviewee in previous job roles? This is a really sensitive question because it deals with, well, firstly, we've got the data protection elements. It is sensitive health data. In terms of asking this type of information, there really needs to be a legitimate reason to ask for this to avoid claims of potential disability discrimination. So if these are being asked in order to choose one employee who doesn't make such disclosures over the other, you're obviously at risk of a disability discrimination claim. Rights apply to applicants as well as employees. But if it's to put in place reasonable adjustments for the interview process itself, or to understand what the employer can do to support the person into work, then it may be justified. So you really need to think about the reasons why this is being asked. Think about the risks, quite high risks of disability discrimination. And also think about the data protection elements. What are you doing with that information, and how are you keeping it confidential and secure?
Thanks, Lauren. We've got a question here. If your employer is aware that you have a mental health condition and do not make reasonable adjustments when you have raised this with them, what should you do? I think my advice would be to raise a grievance to formalise the issues. Once you've put a grievance in writing, then your employer is obliged to investigate and give you an outcome as regards your requests. If you're not satisfied with the outcome, then you have a chance to appeal and can ultimately bring a claim for failure to make reasonable adjustments in the employment tribunal for any financial loss and the injury to feelings element that we've mentioned in today's talk. Hope that helps.
This is quite a good one. So where does an organisation have responsibility around mental health beyond staff, and does the reach go to contractors and beyond? The answer is yes. So the Equality Act doesn't just apply directly to employees, workers, contractors, and there's also health and safety obligations set out in the law to protect customers, staff equally. So yes, it's quite a wide reach, which is why it's really important.
Yeah, and the Equality Act also covers service providers as well. So, for instance, if a passenger on a bus. So yes, it definitely does extend beyond your own employees. Are there occurrences where a former member of staff can make a claim after signing a settlement agreement if they felt under pressure? I think this is probably talking about some coercion, which goes beyond today. But in simple terms, there's nothing ever to stop a former employee from bringing a claim. It's then down to the employer to challenge that claim. And there is case law that says if a settlement agreement has been signed and it's been properly advised upon by an independent advisor, then it should bind the parties going forwards. So your legal team would be able to rely on that case law.
And there's been a question about is the burden on the employee to report their mental health issues. It's basically, it involves both parties. So there's an element that the employer needs to be aware in order to avoid the risk of discrimination. So it does require them to make reasonable inquiries, spotting those signs. Employers, there's a legal test that they ought to be reasonably aware. So through informal discussions and ways that they might otherwise know. It is always safer from the employee's perspective to put the employer on actual notice and make these disclosures. But even if that doesn't happen, it's not strictly the burden on the employee. The employer does have duties, and there's arguments that they ought to be reasonably aware in some aspects of the Equality Act provisions.
Okay, I think we've got time for one more, which is, does the employee have any less protection if they've been in an organisation for less than 2 years? And do they need to have outlined any mental health illness at the outset of their employment? I think we've covered this today, but just to reiterate, the right not to be discriminated is not even just a day one right, it's pre-day one. So it applies to applicants as well as employees and workers. So no, you don't have to be employed for 2 years in order to gain right not to be discriminated against if you have a disability. So it's overcoming that hurdle. And then in terms of whether you should outline your mental health illness, I think we've highlighted that communication in this is key. So we would say, yes, you need to be transparent about any health conditions that are going to affect your work so that reasonable adjustments can be made, because an employer must have actual or constructive knowledge in order to be sued. So I think we'll pass to David now to wrap up on behalf of CIMA.
Jennifer, Lauren, thank you very much indeed. A great presentation and a terrific amount of information there. It's just my role now is to not only thank you, but also thank those of you who've joined on the webinar. I know there'll be a number who won't have been able to have made it, but will be able to see this and view this again. So thank you all for not only attending, but also the presentation. You'll be receiving in a few hours' time the information, which will be a copy of the recording of a link to the copy of the recording of the webinar, and a link to a copy of the presentation slides. Also, feedback survey, and it'll be terrific if you will please complete this feedback survey, because it does help us determine and identify what you would like us to be working on and presenting to you in the future. So that feedback survey will be terrific. So in conclusion, we're just coming round to 1329. Thank you all very much indeed for joining, and I look forward to you joining us not only in this, but also in any face-to-face events that we're able to hold. And there's a CIPD event that's taking place in the Southwest, where we're presenting a business case. Speak to Suzanne Allen for that if you're able to do that. and are able to travel to Bristol. Meanwhile, Lauren, Jennifer, thank you very much indeed, and thank you all. Have a great day. Cheerio.
Thanks, David.
Bye-bye. Thank you.
Bye.
Bye-bye.
Thanks.